Welcome to the International Business and Law Academy. My name is Hui and I would like to introduce about my presentation on the subject of public international law of the international legal system. First, I would like to discuss one of the case studies. To understand the nature and the function of international laws, right and obligation of the parties. Aegean Sea Continental Shelf and case. Facts. The Turkish government granted license to explore petroleum in undersea location of Aegean Sea, including areas that encroach on the continental shelf of several Greek islands. The Greek government protested Turkey's right to grant license over the contested waters. Turkey rejected the protest but expressed a readiness for negotiations to resolve the territorial dispute. Greece then proposed that the nation differences over the applicable law as well as over the substance of the matters to be referred to International Court of Justice. Turkey answered by expressing hope in that Greece would agree to enter negotiation by adding that in the principle of it considered favorably the proposal to refer the dispute jointly to the Court of Justice. To this effect, Turkey processed talk between the two governments ministerial level. Later, the foreign minister of Greece and Turkey considered the text of a special agreement on considering the submission of matters to the International Court of Justice. So the issue is this case for the sovereignty disputes. What do you think if the two countries to submit their dispute to the International Court of Justice? I would like you all to discuss this case together and talk specifically about the case of the dispute. At the same time, give a justification for the applied theory in this case. Kanla, would you like to start us off?
Okay, I would like to state the facts again that the Turkish government granted licenses to explore for petroleum in undersea locations of the Argentine Sea, including areas that encroach on the continental shelf of several Greek islands. The Greek government protested Turkey's right to grant licenses over the contested water. And Turkey and Greece are two sovereign states. Therefore, I think that this is a dispute over territory and waters, so that it is related to public international law.
How about you, Anne?
I agree with Ruby. In definition, public international law deals with the rights and obligations of sovereign states. Turkey and Greece are indeed two sovereign states. The two countries should submit their dispute to the International Court of Justice.
Yeah, I totally agree. And because he said that Turkey and Greece are two sovereign countries, we should find out if they sign any agreement or is committed to assert that the dispute of the two countries is resolved by the International Court of Justice.
Okay, so as I know, after 2 weeks of discussions, the Prime Minister of both countries met in Brussels and issued a joint communique that stated that the two Prime Ministers had an opportunity to give considerations to the problem which led to the existing situation. As regards to relations between countries, they decided that those problems should be resolved peacefully by means of negotiations, and as regards to the continental shelf of the Aegean Sea by the International Court at The Hague. They defined the general lines on the basis of which the forthcoming meeting of the representative of the two governments would take place.
Okay, I agree with Khan. The communique was issued directly to the media during a press conference at the conclusions of the meeting between the prime ministers and did not bear any signature or initials. The Greek government side is as evidence that the Court of Justice has jurisdiction to hear the dispute. Turkey responds that the communique did not amount to an agreement under international law, where the communique and international agreement that bound the two countries to submit their dispute to the Court of Justice.
Thank you all for the discussion. And before answering this question, to clarify the situation, I would like you to review the theoretical parts of the research paper.
So the nature and function of international law is that the principles are commonly observed by the world community. And these rules are essential to the orderly management of the relations among nations.
And now let's start with the definition. Public international laws deals with the rights and obligations of sovereign states. Meanwhile, private international laws, it regulates the activities of individuals and corporations. Conflicts of laws is where those rules are part of the domestic legal systems of individual nations. Under the doctrine of incorporation, most countries recognize the international law as part of their domestic law to some degree.
And the United Nations in Article 38 of the International Court of Justice Statute, international dispute be resolved by reference to treaties, customs, general principle of law recognized by civilized nations, judicial decisions, and teachings. Treaties and customs are considered to be primary sources of international law.
The most important sources of international laws are found in the bilateral and multilateral treaties that regulates the affair between and among nations. The treaty laws is based on the consent of sovereign nations and nations' complete freedom to determine the required means of expressing consent to the terms of a treaty.
Once again, thank you for the discussion, and now I'm going to talk about the case study. Agency and continental self case. The decision. Yes, in this case, the sovereignty disputes, there is no rules of international law that might preclude a joint of communique from consulting an international agreement to submit a dispute to arbitrations or judicial settlements. Accordingly, whether the communique does not or does consult such an agreement essentially depends on the nature of the act or the transaction to which it's gift or expression. The question is not settled simply by referring to the form. The communique in which the act of transaction embodied in the communique of the Court of Justice must have regard above of all its actual terms and the particular circumstances in which it was drawn up. When considered in the light, the communique does not evidence of any change in Turkey's original positions. The nation should not negotiate their differences before submitting the dispute to the Court of Justice. Thank you all very much, and I would like to thank you, the International Business Law Academy, as well as Dr. Sir.